In this video, we will conclude our look at the UCC's gap filler provisions by focusing in on Article 2's various gap filler terms concerning the delivery of and payment for the goods. The UCC includes all sorts of gap filler provisions regarding delivery of and payment for goods. Because these are gap fillers, these provisions are merely default rules. Stated differently, the parties to a contract can agree to different rules if they want to. The gap fillers apply only in the absence of the parties' agreement to the contrary. But often, parties to a business transaction, especially a routine business transaction, naturally focus their time and attention on the most important terms of the deal. Specifically, they focus on things like price, quantity, and the nature of the goods involved. The parties may not think to address less important details, like delivery and payment terms. When is delivery due? When is payment due? What happens if the goods fail to conform to what the buyer asked for? So unlike quantity or price, in this context, when we're talking about the details of a deal, where the parties to an agreement fail to address the specific aspects of delivery and payment, Article 2's gap filler provisions are much more likely to come into play. Let's start at the very beginning with the most basic obligations of the parties to a contract for the sale of goods, which is described in Section 301 of Article 2. That section says that the seller's basic obligation is to deliver to the buyer the goods required by the contract, and the buyer's basic obligation is to accept and pay the seller for those goods. Note Section 301 does not provide for how those obligations are to be fulfilled or who must perform first, the seller or the buyer. Again, the parties may expressly agree on these points, in which case the parties' agreement governs their contractual obligations. But oftentimes, the parties' agreement may be silent on a question as basic as who has to perform first, the seller or the buyer. So Article 2 provides a relevant gap filler. First, Section 507, subsection 1 says, tender of delivery is a condition to the buyer's duty to accept the goods and to his duty to pay for them. So tender of delivery by seller is a condition on the buyer's obligation to accept and pay for the goods. Stated differently, the buyer's obligation is conditioned upon the seller tendering the goods. If the seller fails to tender the goods, that is, if the seller fails to show up with the goods, then the condition to the buyer's obligation is not met, and therefore, buyer's contingent obligation to accept and pay for the goods is discharged. The buyer does not have to pay the seller for the goods. But note Section 511, subsection 1, which says that unless otherwise agreed, tender of payment is a condition to the seller's duty to tender and complete any delivery. So tender of payment by the buyer is a condition on the seller's obligation to deliver the goods. Stated differently, the seller's obligation to deliver the goods is conditioned upon the buyer's tendering payment for the goods. If the buyer fails to tender payment, then the condition to the seller's obligation is not met, and therefore the seller's contingent obligation to deliver the goods is discharged. The seller does not actually have to deliver the goods to the buyer. Note, both provisions use the term tender. One party's tender of its performance obligation is a condition to the other party's obligation to perform. A question this should immediately raise in your mind is, what does the statute mean by tender? How should we try to answer this question? Well, when dealing with the UCC or any other statute, the first answer should always be to start with the statute. And though that is always an excellent first step, like many words in the UCC does not provide a statutory definition for the word tender. Fortunately, tender is a term that is pretty well understood in contract law. Here is how I like to think of it. Tendering is when you indicate that you're ready, willing, and able to perform your obligations under the contract. So 507 and 511 set up a pair of concurrent conditions. Each party's obligation to perform under the contract is conditioned on the other party tendering its performance. If one party fails to tender its performance, the other party is not obligated to perform. So if the seller fails to first tender the goods, the buyer is not obligated to actually pay the seller, the buyer's obligation to pay is discharged. And if the buyer fails to tender payment for the goods, the seller is not obligated to actually deliver the goods to the buyer. The seller's obligation is discharged. Let's look at each party's obligations a little bit more closely and how Article 2's gap filler provisions deal with each, starting first with the seller's obligation to tender delivery of the goods. First, what is it the seller must tender? The answer is conforming goods. Under Section 601, buyer has a right to conforming goods. What are conforming goods? That term is defined under subsection 2 of Section 106. That subsection provides that conforming goods are goods that conform to the requirements of the contract. So the seller must deliver whatever is required under the contract and make delivery in accordance with the contract. Importantly, Section 307 stipulates that all goods subject to the contract must be delivered by the seller in a single lot or single delivery. Elsewhere, we'll see that the UCC addresses so-called installment contracts, contracts that provide that the goods will be tendered in multiple installments. Delivery by installment, however, is something the parties must agree to. The default rule under Section 307 of Article 2 is that in the absence of the parties' agreement to the contrary, there is no installment contract. There are no installment deliveries. The seller must deliver all the goods in a single lot. Second, as to when the seller must tender conforming goods, subsection 1 of 309 provides the relevant default rule. That gap filler applies if the parties' agreement does not provide a deadline for delivery. That provision says that the seller's tender of conforming goods must be within a reasonable time. Of course, what constitutes a reasonable time is extremely context specific, entirely dependent on the facts and circumstances of a transaction, including the nature of the goods involved, the purpose of the goods, and whether the seller had knowledge of the buyer's expectations or vice versa. Finally, as to where the seller must tender conforming goods, Section 308 of Article 2 provides the relevant gap filler provision or default rule. That section provides that in the absence of the parties' agreement to the contrary, the seller must tender the goods to the buyer at the seller's place of business, or if the seller does not have a place of business, then at the seller's residence. Note, this default rule assumes that the seller will directly tender goods to the buyer. We'll look at this assumption more closely in a moment, but commonly, the parties' agreement will require or authorize the seller to use a third-party carrier to deliver the goods. Think UPS or FedEx or some private freight company or carrier. Where the seller uses an intermediary, a third-party carrier, to ship or deliver the goods to the buyer, the UCC has different rules that apply. But in the absence of the parties' agreement to the contrary, specifically requiring or authorizing the seller to use a third-party carrier, Article 2's default gap filler contemplates that the seller will directly tender to the buyer at the seller's place. Once the seller is ready to tender the goods, three other categories of gap filler provisions come into place. First, the buyer's right to inspect the goods. Second, the buyer's obligation to pay for the goods. And third, when does the risk of loss for the goods pass from the seller to the buyer? Let's start with the first of these, the buyer's right to inspect the goods. In the absence of the parties' agreement to the contrary, once the seller tenders the goods, but before the buyer pays, under 513 subsection 1, the buyer has a right to inspect the good. Specifically, the buyer has a right before payment or acceptance to inspect the goods at any reasonable place and time and in any reasonable manner. So before the buyer must actually pay the seller, the buyer has a right to inspect in a reasonable manner and for any reasonable period of time to ensure the goods are conforming to the contract. Again, what constitutes a reasonable inspection will depend entirely on the facts and circumstances of a specific transaction, but the inspection must be geared toward determining if the goods comply with the requirements of the contract, which will in turn depend on what was specifically warranted about the goods in the parties' contract, and how long it would take to reasonably inspect for such specifics. After the buyer's inspection, what happens next is something that we will come back to and look at more closely later in this course when we address remedies. So for now, this is simply a preview of where we will be going in the next few weeks. But this preview will also highlight the many gap fillers of Article 2 regarding delivery and payment for the goods. After the buyer has had an opportunity to inspect the goods to see if they conform to the requirements of the parties' contract, the buyer has a binary choice to make. The buyer must either accept the goods or reject the goods, and the buyer must do one or the other. The buyer cannot do both. And if the buyer fails to seasonably reject the goods, that is, reject them within a reasonable time, that failure to reject itself constitutes an acceptance of the goods. Let's start with acceptance. What happens when the buyer elects to accept the goods that the seller has tendered? Two very important points to make about the buyer's acceptance of goods. First, buyer's acceptance of goods is not the same thing as an offeree accepting an offer. Acceptance of the goods and acceptance of an offer are two completely and unrelated concepts. An offeree's acceptance of an offer creates a contract between the offeree and the offeror. The buyer's acceptance of goods relates to the performance of a contract already formed. If the buyer rejects goods, the buyer is rejecting the seller's tender. Essentially, by rejecting the goods, the buyer is alleging that the seller's performance, that is, the goods themselves or the seller's manner of tender, is in breach of their contract. The second important point to make is that buyers taking possession of the goods is not the same thing as buyer accepting the goods. Again, Buyer's possession and acceptance of the goods are two totally separate and unrelated things. Sometimes inspection by the buyer is impossible without the buyer taking possession of the goods. Sometimes buyer taking possession of the seller's goods may be a necessary precursor to the buyer's acceptance or rejection of the seller's tender. And nothing in Article 2 says that buyers taking possession of the goods constitutes an acceptance of those goods. If buyer accepts the seller's tender of goods, then that acceptance carries with it certain legal consequences. First, buyer can no longer reject the goods that the buyer has accepted, and second, more consequentially, upon acceptance, buyer must pay the seller the contract price for the goods accepted. Having now covered the gap fillers relating to the buyer's acceptance of the goods, let's also briefly look at the rules relating to the buyer's rejection of the seller's tender. As we will discuss in a later module, in the absence of the parties' agreement to the contrary, buyer has a right to reject goods that do not fully conform to the requirements of the contract. This is known as the perfect tender rule and is codified in section 601 of Article 2. When the buyer rejects, and indeed at any time before the buyer accepts the goods remain the property of the seller. The buyer may not exercise ownership over the goods she rejects. In fact, in the absence of the parties' agreement to the contrary, the buyer must take reasonable care of rejected goods in her possession and hold them for the seller to retake. Note, the buyer's decision to reject goods is distinct from the buyer's legal right to do so. Nothing can stop a buyer from rejecting conforming goods, but the rejection of conforming goods is considered a wrongful rejection. Wrongful rejection because it breaches the buyer's obligations under the contract. Specifically, it breaches the buyer's contractual obligation to accept a conforming tender by the seller. As a result, even though the buyer has the power to reject a conforming tender of goods, it does not have a legal right to do so. The buyer's wrongful rejection means that the seller will have a claim against the buyer for a breach of the party's contract. But let's assume for the moment that the seller's tender of goods is non-conforming and therefore the buyer rightfully rejects the seller's tender. In that case, the buyer has no obligation to pay the seller for the rightfully rejected goods. And not only does the buyer have no obligation to pay, the buyer has a claim against the seller for breach, the breach being the seller's failure to tender conforming goods, goods that conform to the requirements of the party's contract. One final note about the buyer's payment obligation. Although the UCC's default rule is that the buyer must pay only upon inspecting the goods tendered by the seller, the parties may agree otherwise. Specifically, the parties may override the Article 2 gap filler by agreeing that the buyer must prepay for the goods, pay for the goods before inspecting. For example, perhaps the parties will agree that the buyer will pay for the goods before they are ever tendered to the buyer. Or maybe the party's contract says that the buyer will pay for the goods after they are tendered, but before the buyer can inspect the goods. Whatever the case may be, whenever the party's contract provides that the buyer must pay for the goods before the buyer inspects the goods, the buyer's prepayment does not affect the buyer's right to inspect the goods. Stated differently, the buyer's prepayment, in accordance with the party's contract, does not mean that the buyer is accepting the good. Paying is not the same thing as accepting goods. Let me re-emphasize this. Paying is not the same thing as accepting. Buyer still has a right to inspect the goods for conformity and to reject non-conforming goods. Nothing about the parties' agreement requiring prepayment changes these rights. The primary difference in this scenario is that instead of withholding payment for the rejected goods, the buyer must instead seek refund of its prepaid amounts from the seller. Of course, the buyer might also elect to accept the goods, in which case there would be no need to seek a refund, assuming the seller's tender was conforming. Let's finish up by looking at Article 2's default gap filler provisions regarding risk of loss. In particular, what we are interested in now is who, as between the buyer and the seller, will bear the financial loss if the goods are lost or destroyed, either while the seller is in the process of tendering the goods to the buyer or the buyer is in the process of inspecting them. As we consider Article 2's gap filler provisions regarding this question, note that we will be making two important assumptions. The first assumption is that as with any of Article 2's gap fillers, we are assuming that there is no agreement to the contrary between the parties. Specifically, we are assuming that the parties' agreement does not address when the risk of loss passes from the seller to the buyer. And it is because the parties' agreement does not address that issue that we must look to the default rules of Article 2 in the first place. Like any other aspect of the transaction, however, the parties are free to agree upon their own rules regarding when the risk of loss passes from the seller to the buyer. But the question of risk of loss is one that parties commonly neglect to address ex ante in their agreement. After all, we are talking about a scenario where something unexpected happens, a mishap that damages or destroys the goods in the process of the seller tendering them to the buyer for acceptance. The second assumption we are making here is that the goods are being tendered by the seller directly to the buyer without the use of some intermediary third-party carrier, what I will sometimes refer to as a direct tender of the goods. As we noted already, in the absence of an agreement to the contrary, Article 2's default rule assumes that the seller will make a direct tender of the goods. But as mentioned earlier, instead of a direct tender, the parties' agreement may require or authorize the seller to use a third-party carrier to deliver the goods. This is especially common if the buyer and the seller are not located near one another. Maybe the seller is in Utah and the buyer in Oregon. Where the parties' contract contemplates the use of an intermediary, the contract can come in one of two flavors. One flavor is called a shipment contract, which requires the seller to simply tender conforming goods into the hands of the carrier, at which point in time the seller's obligation is fully performed. The other flavor is called a destination contract, which requires the seller to tender conforming goods into the hands of the buyer, and not merely the third-party carrier. Under a destination contract, the seller's performance obligation is only completed once the goods arrive at the buyer's destination. Where the parties agree to a shipment or destination contract, Article 2 provides for different gap fillers concerning when the risk of loss passes. But for the purposes of this course, we can make the simplifying assumption that the seller will be making a direct tender to the buyer, just so we can get a taste of how Article 2's default risk of loss rules operate. So assuming a direct tender of goods, and in the absence of an agreement to the contrary, when does the risk of loss transfer from the seller to the buyer? Subsection 3 of 509 provides the relevant gap filler term. And to keep things nice and complicated, the gap filler distinguishes between merchants and non-merchant sellers. If the seller is a merchant, then the risk of loss shifts to the buyer upon the buyer's receipt of conforming goods. If, however, the seller is not a merchant, then the risk of loss shifts upon the seller's tender of delivery of conforming goods. So the subsection gives us this two-part default rule. But note, it gets more complicated than that, because we still need to understand what Article 2 means by receipt and tender of delivery. Receipt is a defined term under Article 2. Specifically, it's defined under subsection 1c of section 103. That subsection defines receipt to mean taking physical possession of the goods. Likewise, tender of delivery is itself described in subsection 1 of 503. That subsection defines tender to require two things of the seller. First, the seller must provide buyer with access to the goods, that is, to put and hold conforming goods at the buyer's disposition. And second, the seller must provide the buyer with reasonable notice necessary so that the buyer knows she may now take delivery of the goods. So under these gap filler provisions, it seems that in the typical transaction, the risk of loss passes on to the buyer just a touch earlier in the case of a non-merchant seller as compared to a merchant seller. So with risk of loss behind us, that finishes our look at Article 2's gap filler provisions. The provisions included in Article 2 that fill in any gaps left open by the parties' express agreement, the default rules that bind contract parties in the absence of the parties' agreement otherwise. As we said at the outset, Article 2 includes many gap filler provisions, and in this module we only looked at some of the most important. But in doing so, you now have a sense of the role gap fillers play in a contract for the sale of goods. In next week's module, we will continue our examination into the terms of a contract for the sale of goods by looking at two specific kinds of terms: warranty disclaimers and provisions that limit the remedies available in the event of one party's breach.